creates the crime of engaging in a street stunt. It also provides the criminal penalties for violating that crime, and it adds the new crime as a method of committing, fleeing, or attempting to elude a police officer. Section 1 creates a new section of law that's creating the new crime of engaging in a street stunt. The crime is defined as operating a motor vehicle in a group of 2 or more vehicles while engaging in a course of conduct affecting other vehicular traffic in an intersection or roadway, disrupting the normal flow of traffic, and either causing other drivers or persons on or near the roadway to remain stopped when such drivers or persons are otherwise legally entitled to proceed, or to take evasive action to avoid being struck by a motor vehicle when a reasonable person would fear for the safety of themselves or others, or action that results in damage to another person's vehicle or property, or results in injury to the person. Engaging in a street stunt as defined in subsection A1 would be a Class A misdemeanor on the first conviction and a severity level 10 person felony on a second or subsequent conviction. And then engaging in a street stunt as defined in subsections A2 or A3 is a severity level 9 person felony on a first conviction, and then it raises to a severity level 5 person felony on a second or subsequent. The section also defines course of conduct, which means 3 or more of the listed traffic infractions. You can see those listed there. There's quite a few of them. Over a period of time, the evidence is a continuity of purpose. A person who violates this new section would also be able to be prosecuted for any offense in the Kansas Criminal Code. Section 2 amends KSA 81568. That's the statute that criminalizes fleeing or attempting to elude a police officer. That section is amended to provide that a person violates the section when they knowingly fail or refuse to bring their vehicle to a stop, or they otherwise flee or attempt to elude police when given a visual or audible signal to bring the vehicle to a stop, when that person is attempting to elude capture for the commission of engaging in a street stunt. And violation of that new version of the offense would be a severity level 7 person felony. And I can take any questions.
Thank you, Natalie. Can you tell me what the current charge is for flee and elude? What level is that?
Yes, thank you, Mr. Chairman. So there's actually a lot of different variations of fleeing or attempting to elude a police officer. And you can see that crime, it starts on page 3 and then over on page 4. So it kind of depends on the type of violation that you're committing, but some of them are a severity level 9. This one's going to be a 7 along with B3. So there is already a version that's a 7. But then a couple of the more minor offenses are a Class B non-person or a Class A non-person misdemeanor.
Okay, thank you. So there's a kind of a range.
Yeah.
Very good. Committee questions for Natalie? All right, not seeing any. Oh, Representative Slingensieben?
So this is limited to vehicular fleeing and eluding? Is that, did I understand that correctly? No. Because we had a bill.
Let's ask Natalie.
Are you talking about the new crime of a street stunt or just the part of fleeing and eluding?
It's the part of fleeing and eluding for the moment.
Yeah, so fleeing and eluding, the definition of that starts on page 3, starting at line 6. And so it leads in with any driver of a motor vehicle who knowingly does those things. So, yeah.
Thank you, Mr. Chair.
Representative Carmichael.
Thank you, Mr. Chair. But to follow up on Representative Schligensiepen's excellent question, the new section 1 of the bill that appears on page 1 and continues through page 2 over to the top of page 3 appears to me to be a new traffic offense.
Mr. Chairman, Representative Carmichael, I wouldn't actually call it a traffic offense because it's a crime. So these are going to be misdemeanors and felony level, but they do involve motor vehicles there.
You presumed correctly what my next question or two was. The commission of this new felony offense appears to be predicated, in part at least, on 2 drivers of motor vehicles committing what are, I think, already described as standard type traffic offenses that are misdemeanors or traffic infractions even. I think parking is even included here. Am I following that?
Yes, Mr. Chairman, Representative Carmichael, So if you start the beginning right on line 9, there's a prerequisite to the commission of the crime that you're operating a motor vehicle in a group of 2 or more vehicles. So it would be kind of similar to flee and elude. I mean, I don't know where it'll be codified, but it's not really like a traffic infraction that we think about. It's an actual like criminal offense.
Yeah, it's a
but
felony.
you have to be committing those traffic infractions in order to.
Finally, just so I understand, Mr. Chair, 2 vehicles doing things like backing up or not having tail lights, a whole bunch of things like that are the predicate offenses almost, if you wish.
Mr. Chairman, Representative Carmichael, so that list of offenses is what makes up the definition of a course of conduct, but you do still have to either be, 1, causing other drivers or persons to remain stopped, or do an evasive action to avoid you, or damage another person's vehicle or property, or injure the person.
Serious problem right in front of my house in Wichita is we have what was supposed to be a traffic circle, but it's not a traffic circle anymore. It's just a big pad of concrete. And so people like to come out and turn kitties out there, squealing their tires round and round. But in order to qualify under this statute, they would, 1, have to be 2 cars, I guess, doing this, and 2, other vehicles would have to take some types of action in response to people out there turning kitties in front of my house. And I'm just trying to make sure, I could be wrong. Help me out.
Mr. Chairman, so they wouldn't, so they do have to be 2 vehicles, but they wouldn't necessarily have to cause someone to remain stopped or something, because they could do 2 or 3. They could cause damage to another person's vehicle or property, or they could injure another person. So, but they do have to be 2 vehicles.
But running over my kitty while turning kitties would not qualify. Thank you. I'll withdraw the question. I guess it is property.
property,
Kitties
yeah,
are property. I think of them as human, but thank you.
Yeah.
Flow of thought.
Carrying on, shall we?
Snowflakes. Whoa.
Any other questions for the reviser? Not stories, not soliloquies, not paragraphs. Any other questions for the reviser? Very good. Thank you, Natalie. We're now pleased to hear from Lieutenant Chris Marceau of the Wichita Police Department, who is joining us on WebEx. Lieutenant, thanks for joining us.
Thank you. Can you hear me okay?
I can.
Chairman Owens and members of the committee, my name is Lieutenant Chris Marceau, and I have served 18 years with the Wichita Police Department. I currently work in the Special Investigations Bureau, which is responsible for investigating, providing follow-up investigation, or assisting in the investigation of cases related to narcotics, illegal substances, vice crimes, asset forfeitures, and any investigation requiring the use of covert resources. Being responsive to community concerns is the Bureau's highest priority. As a significant concern in the community started to develop in September 2022, when Wichita began to see a rise in groups of motorcycles, particularly smaller motorcycles, committing several traffic violations and other crimes. These groups are often referred to by citizens as stunt riders or hooligans. Some of these packs of motorcycle riders have shut down intersections, often blowing through red lights and stunting, causing safety concerns to innocent drivers. A pack mentality has evolved that, at times, used intimidation tactics towards frustrated drivers who became disenchanted with the behavior of these motorcyclists. Several of these cases have resulted in property damage, aggravated assaults, and injuries to innocent victims. To make matters more difficult, many law enforcement agencies have policies that prohibit the pursuit of fleeing vehicles for traffic violations and less serious crimes. While this challenge is a unique one to law enforcement, Wichita is not alone regarding this problem, as this issue has become prevalent in mid-size and large cities throughout the United States. 2 people have died in Wichita because of the reckless and malicious actions of individuals involved in stunting or reckless behavior on motorcycles. On February 20th, 2023, a 48-year-old female pedestrian was struck and killed by a 21-year-old stunt rider who was riding a wheelie near 11th and Broadway. The suspect fled the scene after the accident on his motorcycle and was later apprehended. The following May, just over 3 months later, the same suspect was apprehended for stunning near Waterman and Emporia. On September 1st, 2023, a 19-year-old male motorcyclist fired multiple rounds from a firearm at a vehicle that was occupied by a 72-year-old male and a 69-year-old female. The female was struck by a bullet and died. The suspect fled the scene and was apprehended later. Not long before the incident, the suspect was with a pack of motorcyclists who were engaged in reckless actions at an intersection. As stated above, this unique challenge to law enforcement is not confined to Wichita, but is a growing national problem and will most likely continue to get worse unless we take necessary measures. The relatively low cost and easy access to these smaller motorcycles, partnered with the thrill and excitement that some people get from this type of activity, along with widespread use of social media, has caused this issue to grow over time. I believe that the passing of House Bill number 2656 is a step in the right direction to curtail the illegal behavior. House Bill number 2656 identifies a course of conduct of 3 or more violations from a list that is commonly violated by these packs of 2 or more people over a period of time, however short. The bill creates the crime of engaging in a street stunt that affects other vehicular traffic in an intersection or roadway, causing other drivers or people nearby to fear for their safety or the safety of others. This type of violation would be a misdemeanor for a first conviction and a felony for a second or subsequent convictions. If the behavior results in damage to property or causes injury to another person, the conviction will be a felony. It also adds engaging in a street stunt to the list of crimes included in fleeing or attempting to elude a police officer, making it a felony. Thank you.
Thank you. Committee questions for Lieutenant Marceau. Representative Carmichael.
Thank you, Mr. Chair. Lieutenant Marceau, I want you to know I find your testimony here today persuasive and very helpful.
Thank you.
And to the extent I made remarks about kitties and the like, please don't take my frivolity. I probably should have phrased it that way. But my question to you is, as I looked at your testimony, I saw immediately to your right what appeared to be a Harley Davidson motorcycle with a law enforcement officer on it. Can you tell me who that is?
Yes, sir. That's my grandpa. He rode motorcycles for the Wichita Police Department back in the 1960s.
And that's what I suspected, because I presumed you were of a family well-known and a distinguished career in both law enforcement, who have had well-known and distinguished careers in both law enforcement, the fire service, and even aviation-based law enforcement. Is that all your line of people?
Yes, sir.
Very good. Well, I find this to be never imagined I'd say it, but I think this is probably a worthwhile piece of legislation, Mr. Chair. Thank you, Lieutenant.
Thank you.
Thank you, Lieutenant. You really were persuasive. Additional questions for the Lieutenant? All right, seeing none, thank you very much, sir. We'll now hear from Ed Klump on behalf of our law enforcement associations.
Thank you, Mr. Chairman, committee members. I am here on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers, and my name is Ed Klump, as the chairman noted. We support this. There's not too much I can add to Lieutenant Marceau's testimony. That was excellent testimony. I thought I would, in full disclosure, tell you that our association has worked with the lieutenant and others at Wichita PD in developing this. We worked on it over the summer and into the fall. And we tried to craft something that would distinguish it from just the normal traffic violations that are listed there. And so we did that intentionally by adding the provisions that if you don't interfere with traffic or you don't cause damage to property, or you don't cause an injury, then this doesn't apply and we go back to just the standard traffic ordinances. But if you have a situation where those are involved, that's the type of driving we're trying to address here. And it's kind of like in the attempt to elude statute years ago, where we added the provisions where we made a list of violations and said if you violate 3 or more of those, I think it is, or 2 or more, whatever it is, then that's a higher level of penalty. And so that's what we were trying to do in formatting this way, is looking at the common violations that were occurring, multiple vehicles, 2 or more vehicles, and they're doing these multiple violations. And if you see the videos of this, I mean, they're pretty powerful. I mean, I've seen videos from Wichita where they have motorcycles who are literally at a controlled intersection where traffic is stopped, and they're literally circling cars stopped in the traffic line, intimidating the drivers. They may not damage the vehicle, but they'll pound on the side of the vehicle and scaring the drivers. And it's really an intimidating process and very, very dangerous. And so I'll just stand for questions. I want you to know that, as the lieutenant said, this isn't a Wichita problem. This is actually a nationwide problem now. And it's occurring in many of our cities across Kansas. We think this is a good solution. We think the penalties are right. We intentionally designed it with the first offense being an A misdemeanor. That's kind of a, hey, here's what happens if you keep doing this, and trying to give them that fair warning before they stepped up. So with that, Mr. Chairman, I'll answer questions.
All right, thank you very much. Representative Butler.
Thank you, Mr. Chairman. Mr. Klump, what happens when they're intimidating people like that, they're going around in circles and they're hitting on the cars, and that person, an elderly lady, gets scared, gives it gas, runs over a couple of these motorcycles and the people on? What happens to that person?
Well, I mean, you have to analyze all those situations with all the fact-specific information and exactly what happened. How much did the action of these motorists that are violating these laws contribute to what happened in that person's response? And, you know, certainly you look at, you know, what the seriousness of the property damage, the injury is, and things like that. But ultimately, if there's serious injury, for example, you know, I think you could go back to the causative factor was not the elderly person sitting at the intersection. It was that maybe hit the gas because he got scared and wanted to get out of there. It's the person that caused him to react that way. But those are all, you know, fine details of criminal prosecution that we have to put together in our investigation and present to the prosecutor and see what they can do. And it may just be all we can do is the traffic violations.
Thanks, Mr. Chairman. Yeah, thank you. Because one of the things I teach my wife and I've taught my kids, if you're going to face in a situation like that, you either put it in reverse and get out of this situation, or you drive through it. And so, but it's always a concern, and I'm sure it's a concern for others, that what would happen, because now we see, and depending on where you are, liberal courts that might change it the other way. So thank you.
And in a lot of these situations, you'll see where people will actually get out of their cars and confront, like, the motorcyclists. We've seen them knock the motorcyclists off their motorcycle and things like that, because they're so frustrated that they, you know, they're stuck in this position, they can't get away from it. So,
Representative Eric Smith.
Thank you, Mr. Chair. Thank you for your testimony, Mr. Klump. You know, one of the things that comes to mind for me as an investigator, this is a rather unique, and the only comparison I can make to it is you have a bank robbery with 3 bank robbers or 4 bank robbers, right? And so somebody ends up pulling the trigger and killing someone. All 4 are going to be held liable for that, right?
Correct.
But you're going to have to go through a series of it in the investigation that ties all 4 of them into this crime.
Right.
Likewise with this, if you have multiple riders involved, and say you don't catch them all, I can imagine that the outcry of, well, you're blaming it on 3 of them, there were 7 of them, you know, kind of thing. Has there been any discussion about how that would take place? This is a major a crime scene at times, right?
yeah, it is. And it's just like any other investigation, you know. Sometimes we get these complaints, there could be damage, there could be injury, and we just simply don't have enough information to identify the people that caused it. But, you know, we do an investigation and do our best to identify them. Wichita is fortunate to have a really strong license plate reader program, and a lot of times we can go back in those and follow that person back and get a shot of that license plate or something when, and maybe not with their helmet on or something like that, you never know. But yeah, if the situation's serious enough, we'll conduct an investigation on it.
Yeah, certainly. Representative Carmichael.
Glad you brought up the flock cameras because I was going to bring that up myself. Okay. And just real quickly, for the benefit of some other people on the committee, from a civil standpoint, if you accelerate away from a gang that's circling your vehicle, you're acting in what's known as an emergency situation, and the standard of care is very, very low if you should injure someone who's doing that when you're in an emergency situation. And from a criminal liability standpoint, the law provides multiple excuses and exceptions to criminal prosecution when you're fleeing from someone who's pounding on your vehicle, threatening your life, et cetera. So, I'm hopeful, I'm hopeful the law has already taken care of that. Some years ago, I think it was perhaps in the Judiciary Committee, Chief Atterbury from Bel Air was testifying on behalf of the Chiefs Association, and I can't remember whether we were on the off record or off, but I addressed with him the difficulty we also have in Wichita, that when my wife and I are sitting out on our back patio on a calm Sunday afternoon having a beverage or two, that you can hear motorcycles racing around the 4-lane highways doing circuits almost like a time trial. And some other committee member, I think it was, inquired of Chief Atterbury what to do about that, and he, of course, said, well, call us. But, of course, the problem is that if you call and you say they're here inside of 45 seconds to a minute, they're well over a mile away because they're running well over 60 miles an hour. What I understand is that 2 or more vehicles who are out violating even speeding laws in these types of activities would qualify for the enhanced penalties, particularly if the flock camera should be able to get a nice picture of their tag or maybe their sunglasses without a helmet. Am I understanding that this would be available for that type of purpose as well?
I believe it would be, yes. And again, it's not, you'd have to have more than just the speeding. You have to have 3 of these violations in the course of this conduct.
That's right. It has to be a course of conduct.
Without that, you'd go back to the statute on racing on a highway, for example,
Right.
and what you're talking about. If they're going the wrong way on a divided highway, then you got that violation. But once they get 3 and you have any interference with traffic, damage, injury, then this would kick in.
Final question, Mr. Chair, with your leave. As a general principle, I support the concept that we should limit the impact of criminal statutes to the area where there is in fact a problem, and that we don't make conduct which has no particular consequence, particularly a felony offense. The testimony that I've heard thus far in this hearing concentrates on 2-wheel vehicles that are typically known as motorcycles. If that's all the evidence we have in front of us, why don't we limit this to just that Harley-Davidson motorcycle that Lieutenant Marceau and his family are so justly proud of?
It is not just motorcycles.
Didn't think so. Tell me about it.
So I actually have a video that I should have made arrangements to show here. It's about 1 minute and 15 seconds long, but maybe I can just share it to you somehow. But what'll happen sometimes is you'll have an intersection where you have multi-lane streets coming together. So it's a pretty good sized intersection. And you'll have a group of cars who will come in there and they'll just take over doing the circles and fishtailing and spinning their tires in the intersection. Nobody can move because you can't get through there because the vehicles are going around in circles. And in the process of doing that, very not uncommonly, they'll lose control of that vehicle, they'll smash into another car, just stop there waiting for them to quit their foolishness, or we've even seen them hit pedestrians in doing that.
Come over to my house and sit on the front porch some weekend. I'll buy you a beer and you can see it happen right there. Thank you.
Further questions, committee? All right, seeing none, thanks, Ed. Written only proponent testimony from Colonel Eric Smith, Kansas Highway Patrol, and I don't see any neutral or opponent testimony. All right, so we'll go ahead and close the hearing. Oh, yeah, Representative Titus.
Thank you, Mr. Chairman. Just a follow-up question for the revisor. Would the definition of motor vehicle in the Uniform Act regulating traffic be what applies to this ultimately?
Mr. Chairman, Representative Titus, yeah, yeah.
Anything else, committee? All right, seeing none, we'll close the hearing on House Bill 2656 and move into the hearing on House Bill 2353 and ask Natalie to give us an overview, please.
Thank you, Mr. Chairman. House Bill 2353 increases the amount of time a person can be held for treatment and adds criteria for when continued treatment may be ordered under the Care and Treatment Act for Mentally Ill Persons. Section 1 amends KSA 592958. That's the statute in the Care and Treatment Act allowing for ex parte emergency orders. Current law there provides that an order expires at 5 p.m. on the second day the district court is open after its issuance. This bill would change that to have such an order expire on the third day the district court is open after its issuance. Section 2 amends KSA 592959. That's the statute related to temporary custody orders. Current law there provides that when a request for a temporary custody order is filed, the court is required to set that matter for hearing to be held not later than the close of business the second day the court is open after its filing. This bill would change that to require that hearing to be held before the close of business the third day that the court is open after its filing. Section 3 amends KSA 592967. That's the statute related to orders for outpatient treatment. Current law provides there that an order for outpatient treatment may be entered by the court at any time in lieu of any type of order that would have required inpatient care and treatment. If the court finds that the patient is likely to comply with that outpatient order and is not likely to be a danger to the community or be likely to cause harm to themselves or others while subject to that order. This bill leaves that standard in place and adds that alternatively, the court can order such an order if the patient is in need of outpatient treatment to prevent a relapse or deterioration that would likely result in serious bodily harm to self or others, a substantial harm to the patient's well-being, substantial damage to another person's property, or serious physical or mental debilitation to the patient. The bill also requires that if that outpatient treatment is ordered, all directives and treatment plans that are required by the head of the outpatient facility have to be provided to the court in writing within 10 days after the order for outpatient treatment is issued. And failure to provide that information would not be grounds for dismissal of the order unless that failure is in bad faith. Current law in that section and subsection E provides that an ex parte emergency order issued for noncompliance with one of those outpatient treatment orders shall be issued by the court shall expire on 5 p.m. the second day the district court is open after that patient is taken into custody. This bill would change that to the third day after the patient's taken into custody. Subsection F currently requires that upon taking a patient into custody pursuant to an ex parte emergency order and ordering involuntary inpatient care, the court is required to set that matter for hearing not later than the close of business on the second day the court is open for business after that patient's taken into custody. This bill would change that to be the close of business on the third day they're open after the patient's taken into custody. And finally, Section 4 amends KSA 592969. That's the statute about hearings to review the status of patients. Current law there provides that upon completion of the hearing, if the court finds by clear and convincing evidence that the patient continues to be a mentally ill person subject to involuntary commitment under the Act, then the court shall order continued treatment for a specified period of time not to exceed 3 months. This bill would allow that treatment to be ordered for a time period not to exceed 6 months. I would note, just as a technical matter, this bill was introduced last year. And so if it were to be worked, we would need a technical amendment to bring it into compliance with the constitutional requirements. And I can take any questions.
No problem. Thank you, Natalie. Committee questions for Natalie? All right, seeing none, thank you very much. We'll now call on our proponents. Drew Atkins, Commissioner of Behavioral Health Services, Kansas Department for Aging and Disability Services. While he's coming up to the podium, they'll be handing out an amendment. So as mentioned, this bill was introduced last year and was not heard last year, but all the parties, as you can see, many of them listed, worked diligently in the off-season to prepare this amendment so that everybody was on board with these changes, which is certainly the way we like to see legislation being done. So that's what's being passed out. I'll turn the time over to you, sir.
Thank you, Chairman Owens and members of the committee. First, thank you for allowing KDADS to offer proponent testimony. I'll keep my comments short. As mentioned earlier, we have a lot of stakeholders here that have a lot of feedback that is positive. And so just a couple of notes from the written testimony in front of you that I wanted to highlight. The Assisted Outpatient Treatment Program, AOT, is a program that does utilize outpatient treatment orders to help those with serious mental illness, mainly schizophrenia, bipolar, and schizoaffective disorder, and those who have a repeat history of hospitalization, medical non-adherence, and many times they don't have the recognizance that they are ill or don't realize they are ill. It's important to note that AOT is a civil court intervention that, in conjunction with the local mental health centers, ensures that the participant receives the services that they need and that the participant is required to participate in that treatment. Again, as mentioned earlier, the changes requested in House Bill 2353 have been requested by AOT stakeholders across the state. We have spent a lot of time, multiple meetings for multiple months over the last year to get to the point that we're at, and I'm very proud of that, and I think you'll hear more about that. Just to highlight the changes quickly, and I'm sure we can dive into this if need be. The changes to the AOT program included in House Bill 2353 are extending the ex parte emergency custody order from 2 days to 3 days, adding decompensation standards to the outpatient treatment order criteria, providing the directive and treatment plans to the court, and extending initial outpatient treatment order from 3 months to 6 months. Certainly, we would be remiss in not recognizing the work, again, that went into this, and just a few stakeholders we want to thank. We had an assistant outpatient treatment judge in Johnson County, Judge Juvenile, that helped us instrumentally in this, so I want to give him a kudos and thank you. We had our district attorney offices. I think we have multiple there, but I know that Johnson County was involved in that too. Certainly our Association of Community Mental Health Centers in partnership there. Our Disability Rights Center, and also Mental Health of America Heartland. They played a large role. I believe you have some testimony from them in front of you, and we've got some behind me as well. But it was a pleasure, and it was neat to see the process play out over the past month on top of all the KDADs and other state agency staff that we had helping. I would just lastly add, please consider passing this. We do believe that this is something that can help for individuals that have serious mental illness and those specific diagnoses mentioned. We do believe this is an incredible program, and we have a lot of data to prove that. I'm happy to answer questions at the appropriate time.
Sure, committee, any questions for Mr. Atkins? Representative Carmichael.
Thank you, Mr. Chair. 2 areas of inquiry. One is of general scope. Just for at least my edification, it's been 40 years or more since I've been involved with this type of a commitment and perhaps a different statutory scheme. How does someone end up being subject to one of these, and I don't know whether you call it a commitment order, a holding order, just educate me. How does a person end up with this ex parte order in place?
Excellent question, Mr. Chair, members of the committee. So an individual would end up in this circumstance after being screened for our state hospitalization. So our state psychiatric hospital is one of our 2 mental health state psychiatric institutions. They would then be discharged from that institution into a custody in the community, and they would be considered for this program. And again, This is not going to serve a lot of individuals. This is going to serve a very, very small amount of individuals, but those diagnoses for the schizophrenia, bipolar, and schizoaffective disorder, they would then qualify for the program. And it would take all of the coordination of the local mental health center, the district court, as well as the individual.
Mr. Chair, I fear I may go past my self-imposed two-question limit, but so does this only apply to someone who is coming out of KDADS type programs at a state mental hospital, or does it apply to people who've been taken off the street because they're engaging in aberrant behavior? In my community, they end up at a place called ComCare where they're evaluated and they're held for a period of time, and eventually judges make determinations as to where we go from here. Help me understand this better, because I thought you were saying your answer, it's only for people who've already been in the state mental hospital.
Correct, and I'll double check that. I've got a subject matter expert in the audience, so she can keep me honest here. It would also apply to individuals in the community.
I want to clarify. Are you asking specifically?
If I could ask you to come up, nobody online can hear you unless you're speaking into a microphone.
I appreciate your patience, Mr. Chair. I just want to get this clear in my mind what population we're talking about.
Provide your name,
Just
please.
to clarify, are you?
We need to hear your name.
Yep,
My name is Jessica Mays. I am the AOT program coordinator at KDADS.
thank you.
Thank you.
Are you asking just about the ex parte custody hold, or are you asking about the outpatient treatment order? Because we are looking at two different sets of statutes.
Yeah, and that shows you my 40 years of ignorance and what I've forgotten and how the law may have changed. Either or, whatever's covered in this law that you're asking me to pass, I need to know about how that works.
Ex parte emergency custody hold is usually petitioned through the court to a civil court, where that person is picked up and then put into an emergency crisis situation.
Okay?
From that point, they're evaluated, and then they're determined whether or not they need inpatient treatment. Current statute, my program or outpatient treatment orders don't come into play until that person has been hospitalized at a state hospital and then released. Well, I guess released would not be the proper term, and then discharged to an AOT program or an outpatient treatment order.
And so this extension of the time that they can be, quote, held applies to both of these circumstances. Is that correct?
Yes and no.
Okay.
2 to 3 day change is that emergency custody hold, that initial hold. Someone is in crisis, they've been court ordered to receive emergency evaluation. The change allows us an extra day for detox or for consideration and making sure that that person can be stabilized to the best of the ability before they go before the court. The change from the 3 months to the 6 months on the initial outpatient treatment order is because the 3 months, it's almost like a tease. You're put on a court order and you're told you've got 3 months. And so our patients start complying the first 2 months, and they're doing medication and they're on their therapy, and then they go, oh, I'm out of here in a month. So they stop complying. If we initially put that 6 month into place, it not only causes transparency because they know their order is up for judicial review every 6 months, but it also makes it so that those initial 6 months are productive, as opposed to 2 months of productive with a break, and then we have to start all over, and then we have another 3 months before, or 6 months before we have to do another review.
Doctor, your testimony has been very helpful in answering my questions, clearing up my confusion. Mr. Chair, you'll be glad to know that she answered all my questions without me asking them. Thank you.
Thank you. Man, we've just got a persuasive group today. This is impressive. Excellent. Any additional questions for Mr. Atkins? All right, seeing none, thank you, sir. We will move on to Michelle Ponce, Associate Director, Association of Community Mental Health Centers of Kansas. Thanks for joining us.
Good afternoon. Thank you, Chair Owens and members of the committee. As Representative Owens mentioned, I'm Michelle Ponce. I'm with the Association of Community Mental Health Centers. We represent all 26 licensed mental health centers across the state. We're here in front of you today to provide testimony in support of House Bill 2353. I would like to acknowledge our friends at KDADS and thank them for putting together a very collaborative process over about the last year, which we appreciate being a part of. Currently, 11 or nearly 40% of the community mental health centers are participating in assisted outpatient treatment programs. They are the entities that provide the ordered community-based services. I wanted to share a very brief story that was provided to us from one of our centers. They sent in that within 1 year of participation, 2 of their individuals graduated successfully without any additional crisis contacts or inpatient hospitalizations needed during that time frame. One of those participants, prior to participation in the AOT program, had been hospitalized more than a dozen times before entering the program. To date, he continues to need only minimal supports in the community and is attending all appointments that have been scheduled for him at the mental health center. So they see that as a very successful program. The AOT process requires those participants to participate in the community-based services with the end goal clearly of diverting them from the higher, costlier treatment provided at our hospitals. We support also the amendments that have been proposed to House Bill 2353, as well as sustaining our current AOT programs, as well as expanding additional programs across the state to best meet the needs of this very difficult to serve population. Thank you for the opportunity to speak, and I'll be happy to take questions at the appropriate time.
Certainly, thank you. Any questions for Michelle? Seeing none, thank you. We'll now hear from Susan Crane Lewis, President and CEO, Mental Health America of the Heartland. Thank you for joining us.
Good afternoon, Chairman Owens, members of the committee. I'm Susan Crane Lewis. I'm the President and CEO of Mental Health America of the Heartland, a mental health advocacy organization founded by a psychiatric patient in 1909, and as such, the oldest civil rights organization in the United States. I come before you today in full support of House Bill 2353. This is a marked change. When the bill was originally drafted last year, my organization prepared to testify in strong opposition to the bill, as the language in that version needed to be made more specific, particularly as it related to serious physical or mental debilitation in the patient, in order to avoid eroding the civil liberties of 1 in 4 Kansans who have mental illness. I need to assert that both then and now, I'm not, and my organization is not categorically opposed to involuntary treatment, but that it must be a last resort and invoked only when an individual is in imminent danger of significant harm to themselves or others. And in these cases, full due process must be afforded to that individual with alacrity. As others have already mentioned, over the intervening months, a small group of very dedicated individuals representing multiple interests, multiple perspectives, spent significant time not only in dialogue, but in researching and crafting alternative language and coming to consensus on language that addressed the concerns of all parties. And that is the language that is before you today. Court-ordered outpatient treatment has been found to be a suitable and effective alternative to involuntary inpatient commitment in many cases. It saves both the community, the court, and the providers time and money, while preserving the rights and dignity of the people in need of that level of intervention. The bill before you provides clarity and appropriate guardrails and due process, while simultaneously enabling the court system and providers to effectively use this option to serve Kansans who are in imminent and urgent need of mental health treatment. I therefore respectfully request the committee pass this bill so that good legislation that assures that people who require involuntary treatment receive it with minimal harm to their civil rights and their dignity, that can be passed in both chambers this session. Thank you for your time. I will stand for questions at the appropriate time.
Sure. Thank you, Susan. Any questions? Representative Schlingensieben.
As the son of a former director of psychology at the Topeka State Hospital and the son of a psychiatrist at the VA hospital, it's interesting to note how much things have changed since May 17th of 1997. There's a lot of opportunity here, and it's very exciting to see it. And if I understood correctly, I think the earlier testimony suggested that, you know, this kind of an approach can save a lot of money from repeated hospitalizations that don't lead to stabilization. And I would add only to that and say not only that, but it also prevents far more significant damage, which is then difficult to address ever, if possible. So I commend you for working this bill. I think it's very important. Thank you.
Thank you. I might add, and didn't contain it in the testimony, one of the things it also does is it enables individuals who are struggling to get treatment in their community, in their town, with their family and friends for informal supports rather than being taken to a hospital miles and miles away where some of those supports aren't available and discharge planning for to come back to their communities is that much harder.
Mr. Chairman, if I may follow up, I think that's an important point, and that was sort of the intent back in 1997. But as we know, that didn't happen, and we've been scrambling ever since. And so this is a really positive development that takes the strengths of the opposing concept and adds the kind of treatment that was once there in a localized fashion and hopefully an effective one. Thank you.
Thank you for your comments.
Thank you. Any further questions, committee? All right, seeing none, thank you very much, Susan. We'll now hear from Chris Jones with the Cicero Institute. He is on WebEx.
Thank you. Dear Chairman Owens and honorable committee members, appreciate the opportunity to testify on HB 2353. I would share that I will go through my written testimony, but would share that the previous proponents have done an excellent job. Right now, I serve as the Senior Fellow and Vice President for Healthcare Policy with Cicero Action, but before joining Cicero, I was the Commissioner of Health and Human Services for the state of North Dakota, which included the state hospital, community behavioral health clinics, and policy. And a long, long time ago, I worked for the hospitals in Great Bend and Garden City, Kansas, which, recognizing I'm an outsider, I wanted you to know that I remember the times of Central Kansas Medical Center in St. Catharines. But I'd like to add that HB 2353 better positions Kansas to respond to its residents in the most needed mental health care by increasing the duration of an initial continued treatment order, which has been shared, and expanding the eligibility criteria for outpatient treatment or AOT. These are sensible changes to improve the accessibility and effectiveness of the state's mental health care. I think it's important to note that the population addressed in this bill are those who are experiencing the most severe symptoms and impairments of mental illness. Involuntary commitment needs to be thoughtful. It is only an option for extreme cases, but it's an essential tool for this high-risk, high-need population. And if you think about the people who are doing this work every day, there is nothing worse than the law preventing them from doing what they need to do. The prevalence of severe mental illness in the criminal justice system and unsheltered homeless populations demonstrates the ways the existing involuntary care framework has been underutilized as a tool to divert individuals whose well-being is rapidly deteriorating and prevent them from becoming homeless or committing crimes due to a lack of care. This bill addresses many of the key reasons for this underutilization. Cursory review of national and statewide data highlights the scale and urgency of this problem. According to the Treatment Advocacy Center, Kansas has more than 70,000 residents suffering from severe mental illness. And while the vast majority of these individuals do not need the highest levels of care, such as those at issue in this bill, it is worth noting that there are only an estimated 300 psychiatric beds in Kansas to care for the most severe cases within that population. The state's bed capacity has fallen by 56% since 2010. And this decline in bed capacity is a concern in its own right. But as it relates to this bill, this trend highlights the need for expanding alternative modes of care, such as outpatient treatment, which is addressed in HB 2353. Like many states, Kansas mental health infrastructure anticipates high levels of criminal involvement among people with severe mental illness, as more than 1/3 of the state's psychiatric beds are within its criminal justice system. Yet even that data point underestimates the connection between mental illness and crime. The Substance Abuse and Mental Health Administration, otherwise known as SAMHSA, estimates that at least 37% of people in jail and 44% of people in prison have mental illnesses. The unsheltered homeless population, which refers to the individuals that we often see sleeping in tents and sleeping bags in parks and on sidewalks, endures similarly alarming rates of mental illness. According to the U.S. Department of Housing and Urban Development, Kansas has seen unsheltered homelessness increase by 85% in the last 5 years. Much of the growth in unsheltered homelessness parallels the increase in prevalence of severe mental illness within that population. Rates of severe mental illness have increased among the total homeless population, have doubled in the last decade, and increased by 42% in the last 5 years. Realize I'm giving you a lot of statistics, but among the unsheltered population, the trends are even worse. Since 2013, the rates of SMI or severe mental illness have increased by 150%, and since 2018 by 114%. The changes enacted by this bill will not fully solve the issues I've outlined, but this bill will put more tools in the hands of families, medical professionals, and officials that will allow the state to better understand demand for the full continuum of care, and today better addresses the most extreme cases of mental illness in Kansas. Thank you, Mr. Chairman, committee members, for your time. I'd be open to any questions you may have.
Thank you very much, Chris. Committee, any questions for Mr. Jones? All right, seeing none, thank you for your time, sir.
Thank you.
As mentioned, there are a slew of written-only proponents, which I would encourage you to take a look at. I'm not seeing any neutral or opponent testimony on this legislation. And so with that in mind, if there's nothing further, I will move to close the hearing on House Bill 2353 and thank everyone that showed up for the hearings on both of these bills today. We will now move back into final action on House Bill 2487. We originally passed this bill out of committee, and when we did so, realized that there were a couple of things that we needed to fix and thought it was better to bring it back to committee to do so. So Natalie, would you give us an overview on 2487 again, please?
Thank you, Mr. Chairman. House Bill 2487 creates immunity from prosecution for certain drug-related offenses, specifically possession of controlled substance and possession of drug paraphernalia, when you are either providing medical assistance or initiating a call with law enforcement to get medical assistance for someone who is having a health emergency due to that controlled substance.
Very good. Committee questions for Natalie. All right, seeing none, we will then consider any amendments as it relates to House Bill 2487. Representative Mon.
Thank you, Mr. Chair. I'm offering an amendment that would change the KSA citations found on paragraphs 10 and 12 on the second page. Basically, currently now it reads 215709B, and we would be changing that to B2. Basically, what this does is it limits the type of paraphernalia that are referenced in 215709, and so it changes the type of paraphernalia that would be subject to this bill.
All right, while we're waiting on that to be sent out, it's on its way. Very good. No, it's already actually out. We can take a look at that. Do I have a second on the amendment? Representative Turk, seconds. Committee, questions on this amendment? Seeing none, you may close on your amendment.
Thank you, Mr. Chair. I move my amendment and close.
All in favor of the Mon amendment, say aye. Aye. Opposed, no. All right, the ayes have it. And we'll get that one added. Those wishing to be recorded, Schlingen, Siepen, Carmichael, and Martinez. In the affirmative. Very good. Do we have another amendment as it relates to House Bill 2487 or discussion? Representative Titus.
Thank you, Mr. Chairman. I have an amendment to remove the additions that were put in the bill by our committee regarding immunity for those serving on probation, community services programs, parole, conditional release, or post-release supervision. In further discussions with law enforcement, this is a position that was more immunity than they were comfortable with, especially given the amount of flexibility that these programs and judges ultimately have in whether or not to get someone in trouble for these violations. And it's more complicated than the broad level of immunity I think that this statute offered. So I'd like to make an amendment to strike those provisions.
Okay, do I have a second on the Titus amendment? Representative Eric Smith, discussion on the amendment. Representative Carmichael.
Thank you, Mr. Chair. My recollection is that the amendment that was put on, that this amendment takes off, was only added after we had had discussion of the advisability of including parolees, probationers, people on conditional release, and perhaps some other categories. And my recollection is there was no objection voiced whatsoever at the hearing. But we did banter it around a little bit amongst ourselves whether we should do this. My recollection is, in the end, I think at least most of us probably concluded that if by happenstance, bad luck, we were exposed to fentanyl and laying on the floor and in need of assistance, we'd probably want a probationer or parolee to call 911, whether we were a law enforcement officer or drug user. And now we're told that somebody had some conversation behind closed doors or somewhere else with law enforcement, and that now we're supposed to back up on what we heard as the testimony in committee. And so in the interest of transparency, I would hope that some member of the committee could tell us who voiced the objection, what the argument was, and why we see now a reversal on the part of at least someone somewhere on law enforcement.
You want to take that, Representative Titus? Go right ahead.
Thank you, Mr. Chairman. I talked to Mr. Klump with the various associations he represents, and it was my understanding that this would cause them to withdraw their support from the bill, and believing that this bill without that addition, whatever your thoughts on that are, is certainly worth moving forward to establish the immunity, even if it's in a limited sense, is worth passing forward rather than risk losing the bill at some point.
Well, I do.
Representative Carmichael.
Thank you. I do appreciate the concern being voiced to you or the chair or whomever it was, because in the end, the perfect is the enemy of the good. And I would hate to see this bill not rise above the line and be passed quickly and promptly to the Senate. It's unfortunate that we are about to risk the lives of law enforcement officers, children, and others whose lives could have been saved if only we'd given this immunity to probationers, parolees, people on conditional release, because they're not going to worry about the fine points when it's time to call 911. If they think they're going to go to jail, there's going to be a certain cohort of people that'll probably let their significant other's child die before they call 911. But I'll support this amendment, but I really think we're not going down the wrong road. Thank you all.
Further discussion on the Titus amendment? All right, all in favor, or would you like to close? Sorry. All right, thank you. All in favor of the Titus amendment, say aye. Aye. Opposed, no. The ayes have it. Those wishing to be recorded are Representative Carmichael, Schlingensieben, and that's it.
Recorded in the affirmative.
Has recorded in the affirmative, just so that we're clear. Very good. Further discussion or amendments as it relates to House Bill 2487. We did. It was Representative Eric Smith. Thank you for clarifying. Any other discussion? All right, then do I have a motion and House Bill 2487 as amended? Representative Schlingensieben.
So I move that we pass this bill out favorable for,
As amended?
yeah, as amended.
Very good. Do I have a second? Representative Turk. Further discussion? All in favor of passing this bill out as amended, say aye. Aye. Opposed, no. Ayes have it. Those wishing to be recorded are Representative Carmichael, Schlingen-Siepen. And that's it? Recorded in the affirmative. Thank you. I'll get that right, I'm sure, at some point. But when it is a unanimous aye, I'm pretty sure.
But unless you announce it was a unanimous aye, people reading the minutes would not know, and I want to answer for what I ought to have to answer for and not be blamed for what I shouldn't be blamed for. Thank you, Mr. Chair.
Duly noted from our ranking minority. All right, committee. Is there any other, anything else for the good of the body? I have two things. First of all, I believe Representative Titus has somebody here he would like to introduce.
Thank you, Mr. Chairman. If I have with me my nephew, Owen Caldwell, who's shadowing me, so please embarrass him and give him a hard time on the way out if you get the opportunity. Thank you.
Yes. Owen just happened to play football back when my son was around his age, a couple years older, and I had the distinct pleasure of coaching Owen when he was in the 3rd grade. So a little bit of history there, which is kind of cool. Representative Schlingen-Siepen, I believe you had something you wanted to share with the committee.
Just briefly, the Northeast Kansas Regional Trauma Committee is in the building downstairs in the classroom to the left. When you come through the doors into the building through the visitor center, they're offering a Stop the Bleed course. It's usually an hour-long course, but legislators don't have a lot of time, so they can compress this into 20 minutes. They're offering this course every hour on the hour. I and my staff took this class, and I have to say, in interest of full disclosure, my daughter is one of the ones teaching it. So I hope you'll go downstairs and take 20 minutes to learn how to save a life. They'll teach you how to apply pressure, they'll teach you how to stuff a wound, and they'll teach you how to apply a tourniquet. And for many who think that tourniquets are no longer aren't the thing to do, they're back in again, and they do save lives. And so therefore, go down and take this 20-minute training. It may prove very useful to you in the future.
Excellent. Next time, have her come up for a few minutes and we'll embarrass her too. All right, committee, thank you for your time. We'll be adjourned. Have a good weekend.